over to Valentina, who is our Spanish language interpreter for the day.
Thank you, Christina. Hi, everyone. Good afternoon. My name is Valentina, and I'm here on behalf of Community Language Cooperative, and I'm here to provide and guarantee your commitment to language justice. Language justice is a type of simultaneous interpretation that seeks to create spaces in which no one language is dominant, spaces in which everyone can participate in the language of their heart. So to achieve this objective, we will be using Zoom's interpretation feature. And what you will see in a couple of minutes is that a new little button that looks like a globe will appear on the bottom bar of your screen. On that same bar where you currently have the buttons for the microphone, for the video, for the chat, etc. It'll be towards your right hand. Once you see this new little this new little button come up, go ahead and click on it and select either English or Spanish as both the language that you will be listening into and speaking into. Everyone that is a monolingual speaker, whether that is in English or in Spanish, must select a language channel. Unless they're fully bilingual, they can choose to ignore the service. If you are joining the meeting on a phone or on a tablet, you will find the same options for interpretation by clicking on the button with the three little dots on the lower right-hand corner of your screen. This button reads More. Hola a todos, a todas y a todos. Buenas tardes. Mi nombre es Valentina y estoy aquí por parte de Community Language Cooperative para ofrecerles y garantizar su compromiso con la justicia del lenguaje. La justicia del lenguaje es un tipo de interpretación simultánea que busca crear espacios en los que no domine ningún idioma, espacios en los que todos puedan participar en el idioma de su corazón. Para lograr este objetivo vamos a utilizar la función de interpretación de Zoom. Lo que verán en un par de minutitos es que aparecerá un nuevo botón que parece un globo terráqueo en la barra inferior de su pantalla, en la misma barra donde ahorita tiene los botones para el micrófono, para el video, para el chat, etc. Va a estar hacia su mano derecha. Una vez que vean este botoncito aparecer, hagan clic en él y seleccionen inglés o español como el idioma en el que desean escuchar y el idioma en el que desean participar. Si usted está en esta sesión por medio de una tableta o de un teléfono, encontrará las mismas opciones para la interpretación haciendo clic en el botón que tiene tres puntitos en la esquina inferior derecha de su pantalla. Ese botoncito dice More o Más. A quick reminder for those of you that do prefer to use English during this meeting, Spanish is 20 to 25% longer than English. So please be aware of your speed. And if you have any questions or any issues whatsoever with this technology, please let the whole group know by means of the chat box so that we can work together to address them. Un breve recordatorio es que la interpretación es simultánea, entonces si tiene alguna, cuando participe, por favor mantenga un ritmo de conversación para que yo pueda comunicar su mensaje completo en el otro idioma. Si tiene alguna pregunta o algún problema con esta tecnología, por favor comuníqueselo al grupo completo a través del chat para que lo podamos resolver en conjunto. Muchas gracias por tenerme por acá. Podemos activar los canales de interpretación ahora. Thank you so much for having me here. We can go.
Great. Thank you so much, Valentina. So we're going to be continuing a discussion that we started last week on House Bill 24-1294. So it is a bill that was passed by the state legislature and signed into law. It's called Mobile Homes in Mobile Home Parks. The Division of Housing cannot change what is in the bill, but we're going to be talking about if there are ways to clarify or help implement what was passed in the bill. And we clarify and implement what is in state statute through a few different processes. One is proposed rulemaking. I see a question in the chat about the timeline of rulemaking, preferred method and deadline for submitting feedback and proposals for rules. My hope is that I will be able to provide on behalf of the program some preliminary draft proposed rules before our next meeting. When we provide that, which we'll do through our email list, or even letting folks know about these meetings, we will also provide a date by which we'd like to receive feedback for us to incorporate before we notice the proposed rules. Then once the proposed rules are noticed in the Colorado Register, there'll be an additional timeline after that to provide comment ahead of a public rulemaking hearing that we're going to hold. And I've got a couple slides with dates, so let me go ahead and get into the slides, which will hopefully provide a bit more detail. So as I mentioned, the presentation is recorded. To ask a question, please type it in the chat box if you are joining by computer or the webinar app. You can also raise your hand if you're joining by the computer or the webinar app on your phone. If you're calling in only, you can dial *9, which is the star button and the number 9 to raise your hand. We will take questions throughout the presentation. Typically at the end of each slide, there'll be a prompt or a pause for questions. A couple guidelines for this meeting. So as I mentioned, we're going to be talking about a bill that was passed by the Colorado General Assembly. They pass laws that become state statute. And then we at the Department of Local Affairs and Division of Housing help to clarify and implement those laws. If you have feedback on the bill itself, so if I say something, this is in the bill, it's in state statute now, it was effective June 4th, or will be effective June 30th. If you have feedback on those types of things, the appropriate venue for providing that feedback is to contact your state legislator, so your state senator or state representative. If you have feedback on, if we're having a discussion about what something means in the statute or how it should be put into practice, that's the type of feedback that we can accept and consider in our rulemaking or in other educational materials we provide. I also want to say that I cannot provide legal advice. Program staff cannot provide legal advice. So please know that this presentation is for educational purposes only. There may be questions that I don't feel comfortable answering because it comes too close to legal advice or that we don't have an answer for yet. So we'll take those back and see if we can provide any more information or education around the topic. We're also not going to be discussing questions about individual mobile home park registrations or pending complaints during this public meeting. If you have questions about registration or complaints, please contact us at our program email address or our toll-free phone number. For those joining by computer, our email address and phone number have been put in the chat. For those joining by phone, our email address is MHPOP, as in Mobile Home Park Oversight Program, at state.co.us. And our phone number is 1-833-924-1147. So I mentioned we're going to be talking about rulemaking to clarify and implement the law, the state statute today. I also wanted to share that there are a couple of different types of clarifying documents that a state agency can share with members of the public. So your feedback today is important. We will evaluate whether it should be considered as part of the proposed rulemaking, or maybe it is better suited for a different type of document. So for example, we have program policies or we issue guidance on laws. We also have educational information on our website, like answers to frequently asked questions. Here's a little bit more about the timeline. So last week we were discussing some emergency rules that the Division of Housing was going to adopt. An email went out yesterday that shared a copy of the emergency rules that were adopted by our Division Director, Allison George. And I apologize, that should be June, not July. So June 17th was the adoption date of those emergency rules. The emergency rules are temporary, and they are only intended to remove things from our rules that are in conflict with statute now. So for example, the definition of a mobile home park changed, and the word occupied or continuous, the concept of continuous occupation was taken out of the definition of a mobile home park. So we have struck that word from our rules when it comes to the mobile home park definition. Another change in the emergency rules is related to the notice period, how far in advance a landlord has to give notice to a homeowner that they're going to be entering a lot. So the notice period used to be 48 hours before lot entry. It is now 72 hours. And that was a change that was made in another bill passed by the General Assembly this session, House Bill 24-1098 on for-cause evictions. So that bill went into effect in April. That's already state law. So our rules are not changing anything except matching the time period in our rules to the time period that's now in state statute. If you did not, I'm assuming everyone here gets our emails, and that's how you found out about the meeting. If for some reason you're not on our email list and you want to join, Michelle, can you provide a link to join our MailChimp in the chat? So we're having public meetings and started last week through next week. These are our initial public meetings on proposed rulemaking. The tentative date of early July for a notice of proposed rulemaking to be published in the Colorado Register. This may get pushed back a little bit based on the adoption date of our emergency rules. So again, stay tuned for an email update on that. Tentatively looking at a rulemaking hearing in late July. This also might get pushed back a little bit to early August. We are likely doing a second round of public meetings and rulemaking on House Bill 24-1294. We're doing this rulemaking now because of the timing that the bill went into effect, the fact that the emergency rules are temporary, so we want to get permanent rules in place before the emergency rules expire. But we don't anticipate that every question or topic is going to be covered in this round of public meetings. So that's one of the reasons we're looking at doing another round of rulemaking and public meetings later this year. We're also looking at potentially needing to discuss a fee increase for the registration fee, and that would be in the second round of rulemaking, if that is something that needs to be discussed.
Christina, there's someone calling in by phone that has their hand raised.
Oh, great. Go ahead and unmute the line and ask your question.
I'm referring to the person calling in from 1-510-876-6982.
Yeah, I was just exploring the website as I'm listening to you guys, and so pretty much all the information that you state in these meetings and stuff is accessible online.
So a lot of the information is going to be accessible online. We will also put up a recording of this on our website if you'd prefer to listen to the recording. But we are planning on this being a discussion today and getting feedback from the participants during the meeting. So that would be if you had feedback or questions that you wanted to ask us live, you could stay on the meeting for that.
Okay, yeah, I'll probably do that. I was just making sure that I have. I'm new to this, and I'm just trying to stay within compliance of what you guys are putting out there for regulations and rules and stuff. And, you know, I just want to say, I believe that you guys are really there for both sides. And it seems like you're finding that happy medium between park owner and compliant tenants. And you know, because we have a lot of tenants that don't stay current and aren't complying to a lot of the issues that we're facing with these new laws and stuff. So I'm going to just listen now. You answered my question for me, so I'm going to just keep listening and go from there.
Sounds good. Thank you so much.
Thank you.
So this is a slide that goes over some of the changes in state law that are now reflected in our, or will be reflected in our program rules when the emergency rules are approved. So I talked about updating the mobile home park definition to reflect the definition in state statute. Updating the notice period for a landlord to enter a mobile home lot. Note that for this notice period, there are the exceptions. If a landlord is entering a lot to post a notice that is required by state law or by the rental agreement. So a landlord doesn't have to post a notice that they're going to be posting a notice. There's also some additional information in our program rules, and I believe it's under Rule 6, that talks about notice for meter readings, for example, or for ongoing construction projects or maintenance projects. So I would refer folks to that rule specifically if they have questions about providing notice for meter readings, or hey, we're going to do tree maintenance. What kind of notice do we have to provide, how far in advance, and things like that. There was a small update in the statute to the time period that a landlord has to provide a tenant a copy of their payment ledger if they request a copy. So in our rules, we had 10 business days. The statute says it has to be provided in 10 calendar days. So our rules reflect that. There is a rule on the complaint process. If a homeowner submits a complaint against a landlord regarding a park rule change, there was a change in statute that clarifies that a homeowner could submit a complaint if a landlord starts enforcing a rule that had not been enforced before. So we added that to our rule on the complaint process. And then there's one place that we updated a statutory reference. In our meeting last week, we went through most of these slides, but didn't quite get to the end. So I'm actually going to start where we left off from our meeting last week, and then we can circle back around as needed. So if there are any slides we don't get to today, I would encourage folks to go back and listen to the recording. One big thing to know about House Bill 24-1294 is that certain parts went into effect on June 4th. Certain parts will be going into effect on June 30th. So these slides, which are also up on the website, separate out what went into effect already, what's in effect already, from what will be going into effect in 10 days. We may also be able to post maybe a highlighted version of the bill on our website that clarifies that. But for educational purposes, you can refer to the way things are separated out in these slides. So I'm going to go ahead and skip ahead. So we left off in the section of the bill that goes into effect on June 30th. And we left off on this slide. in particular. So there was an existing part of state law that said if a landlord is going to close part or all of the park to mobile homes, and that closure would result in the displacement of one or more mobile homes, the homeowners who were being displaced could request compensation from the landlord. And then the statute provides a couple of different options for the type of compensation that can be requested by the homeowner. So the homeowner can request relocation costs to move their mobile home and their belongings. And then they can request the greater of a flat dollar amount or the in-place fair market value of the home as determined by an appraiser hired by the landlord. So this was already in state statute. It was added in 2022, I believe. What changed with this current bill is there is now language that if a park is condemned, says for reasons that are the responsibility of the park owner, and the condemnation would result in the displacement of mobile homes, homeowners can also demand compensation from the landowner for that. Do you have a question? If there's any clarification needed on this new language around condemnation? I see a hand raised, phone number starting in 510876. You can go ahead and ask your question.
Okay, so I'm gonna update some infrastructure in my court, and I'm gonna do it in sections. And I have some tenants that aren't current and aren't compliant. And I may do that section first because I'm not getting any income from that section anyways. What is that gonna entail?
Yeah, so without getting too far into legal advice, so the first thing I'd mention is you might want to speak with an outside attorney about this.
Oh, okay. So no, I hear you. So basically, are there any of these laws that are anything in this thing that are, you know, I don't know, I guess sympathetic towards the situation of some mobile home park owners that are, you know, like I'm just a little guy. I don't have a lot of money. This is an investment for retirement. I don't have access to, you know, thousands of dollars to do repairs, and you know, is there anything that I have as a park owner, or is that something that I still have to go through legal issues with? Or
So I would say the main recourse that a park owner has in state law, if a tenant is not making rent payments or a homeowner is not making rent payments, would be through the tenancy termination and eviction process.
okay. And the way the law reads now, I mean, you know, if they pay you so much money, you have to start that process over and over and over again. When does it become a point where, because I know you guys are kind of like mediators, you're not really on anybody's side. Is that a true statement?
Yes, our directive is to act as a neutral party. Unless and
Okay.
until we
So
make a determination.
if you see, I'm just making an example. If you see a continuance issue with a tenant, you know, crying wolf or just being belligerently uncompliant or on, you know, not updated with rent and stuff, that there are, you are going to help us mediate and solve those kind of problems also.
So the main way that landlords can deal with non-payment of rent is going to be through the eviction process.
Yes.
And yes, state law allows a tenant to pay rent pay back rent up until when a court judgment is issued. We typically don't, through the complaint process, handle complaints of non-payment. That's typically handled through the tenancy termination and
Okay.
eviction process in the courts.
Well, I mean, I know you guys are just you come off as so pro-tenant and so anti-park owner sometimes, and I know that's not the situation, and I know that's not the way you want to be perceived, and I know it's a growing process, and we all got to learn how to work through you guys now because you weren't there. This is all new to everybody, and I just wanted to make sure that I'm doing my process correctly, and thanks for answering the question because you did answer it, and I'll let you continue, and if I have any more concerns, or probably have more questions than concerns, I'll put my hand up, but thank you for your time, and I'll let us get back to this.
Yeah. I will say when we get a complaint in, because we will get complaints from homeowners, for example, that they're maybe facing an eviction, they got a tenancy termination notice. They might say, I paid my rent, or I tried to pay my rent and it wasn't accepted, and the landlord's trying to evict me. We are aware that that is sometimes not the whole story. So we do reach out to the landlord in that situation and ask. And we've had situations where there's some pretty serious health or safety violations that are being alleged to have been committed by the homeowner or one of their guests that the homeowner isn't telling us about when they file a complaint. And so we do ask the landlord about the situation and then rely on you all to tell us, hey, this isn't the whole story. Here's what else is going on. And so that is part of our investigation if we already get a complaint related to an eviction from a homeowner.
No, yeah, I've been dealing with this for a little bit, and I've had not to go into legal or anything, but I know we're responsible for water and plumbing and all these things, but when you have tenants dump hot oil down sewer lines, it ruins sewer lines. When they're putting more than just toilet paper and stuff down there, they plug things, and I'm just glad you guys are there and you're making objective decisions and you research it a little bit deeper than just taking the park owners or the tenants' word for what's going on. And I see that you guys are, because I've had some incidences with you, and you actually listen to both sides and you do your research. And I just want to say thanks for that. And these rules and stuff, they're still a little tenant heavy, and I hope in the future we start getting a happy medium where mobile home park owners have as much as easy rights as tenants, and we can just live together. And like you said, mostly for mobile home parks that are going to stay mobile home parks. I know why you guys are here, because a lot of places were just selling, evicting people, kicking them out in the street and leaving them homeless. And I know why you guys are here now, but I just can't wait till we find a happy balance between mobile home park owner and tenant. And I'll get back to this because I'm learning a lot from you guys today.
Well, thank you so much for your feedback. I appreciate it. We've got a couple questions as well in the chat related to this condemnation provision. And so I think these questions, so I'll read them off for the interpretation and also for folks on the phone. Got a question about whether this right for homeowners to demand compensation only applies if the park is condemned due to park owner neglect. The statute says condemned for reasons that are the responsibility of the park owner. I think that suggests, yes, if there is a lack of maintenance by the landlord for things the landlord is responsible for maintaining, and that's the reason for the condemnation, then a homeowner can demand compensation. I don't know if there are other things that would be the responsibility of the park owner that could lead to a condemnation. So that's probably something for us to do a bit more research on. Does condemnation come from city, county, or state? I believe it could come from any of those, but it's more of a city or county action, but we could do some more research and clarify that. Is this only referring to condemnation of the entire park? Is this to also apply if individual homes are determined to be condemned due to homeowner neglect? No, this would not apply if an individual home is condemned due to that owner of the home's neglect. It would apply if part or all of the park itself was condemned. So there's also a provision that will be going to effect June 30th related to when rent increases and notices of rent increases are prohibited. Now it's my understanding, and I was on family leave during most of the legislative session, but it's my understanding that initial drafts of this bill had a broader prohibition on parks increasing rent, and the final version had a more narrow prohibition. So just a heads up for folks who maybe saw earlier versions of the bill, haven't looked at the final version. This is a summary of what the final version says. So if a landlord has not fully complied with any final federal, state, or local administrative or judicial order, they're prohibited from increasing rent or issuing a notice of a future rent increase until they fully complied. A landlord may also be prohibited from increasing rent if they have been found by the Division of Housing or a court to have violated the section of the Mobile Home Park Act on the landlord's responsibility for maintaining park premises within 12 months before the division or court's order. This prohibition, the second prohibition, doesn't apply if the parties reach a settlement agreement to resolve any potential violations before there's a final agency order or a court order. So division is taking feedback on clarifying or implementing these provisions. So question in the chat, if a tenant happens to file a lawsuit, the landlord cannot raise rents? No. There has to be a final agency, judicial, or government order. So a lawsuit or a complaint that is still pending, is still under investigation or in the legal process, would not prohibit a landlord from raising rents. But if there is a judgment in a court case, if there is, if the division were to issue a notice of violation, and that was not appealed and became a final agency order, then this provision prohibiting rent increases would be in effect. I do anticipate we will probably get some questions about this first part because the language is very broad. So there is any final federal, state, or local order that has not been fully complied with that would prohibit a rent increase. Carol, some great questions in the chat that you may need to consider in rulemaking. So an administrative action would be an action by an administrative agency like the Division of Housing. With regard to your question about whether a lawsuit in another state would lead to a hold on rent increases in Colorado. Part of that would depend on whether there was a judgment or not, but we are doing additional research on this piece. I don't believe that the mobile home park oversight program could put a hold on rent increases for a pending lawsuit. Whether a judge could do that is not something I could speak to. With regard to the question about pet fees, so if a pet fee is treated as rent, yes, a landlord could not increase the pet fee or provide a notice of a pet fee increase if they had not fully complied with an order that was issued against the park. Feedback that if the program implements a fine in the 11th hour before rent increase may be sent out, it could be a problem. We should be required, the program should be required to give 60 days notice on any fines so that a landlord has time to dispute. We'll take that feedback into consideration. There is a separate part of this provision in 38-12-204 that says a landlord can't increase rent if they have unpaid penalties. So I do understand the timing issue that you're bringing up. Like, what if a landlord finds out about a penalty the day before a rent increase was going to take effect and they don't happen to be able to pay it in a day? But do know that it's not, the prohibition doesn't apply to any penalties. It's if there are penalties that are unpaid. But we can discuss that feedback. Thank you. Is there a time frame on the length of time in which a park owner cannot raise rents? So this went into effect in 2021. And it's the answers in the chat as well. Park owner can only raise rents once every 12 months on a particular tenant who has a consecutive tenancy in the park. Question, how do we know if a park owner is in violation or there's an order brought against them? We maintain a list on our website of landlords that may be prohibited from increasing rent. We are aware of so reasons under current law where they may be prohibited from increasing rent is if they don't have an active registration with the division, if they have an unpaid penalty owed to the division, or if they have not fully complied with a final agency order issued by the division. We will be adding, if there are additional landlords based on these new provisions, we'll be adding them to the list. One example I can think of is there are a couple, not a lot that I'm aware of, but there are a couple of mobile home parks that have outstanding wastewater or drinking water compliance issues that we will likely be adding to this list if they're not already on the list of parks prohibited from increasing rent. And those are specifically issues through Colorado Department of Public Health and Environment. So administrative orders issued by another state agencies. Yep, and Michelle, thank you for providing that link in the chat as well to that list. Feedback that order can be better defined, especially concerning for finding if the act was violated. For example, in a preliminary injunction order, there can be a finding that plaintiffs show a reasonable probability of success. When a preliminary injunction order satisfies this finding of the law was violated regulation. For purposes of this provision, will a preliminary injunction order satisfy this finding the law was violated? Great feedback. Comment, it's my understanding that concept of continuous occupancy was removed to include seasonal parks open for the summer months only under the Mobile Home Park Act. How does DOLA plan to enforce provisions with time related to compliance actions during times when summer parks are closed? Great question. So in terms of the landlord's responsibilities, if a park is closed for certain periods or certain months during the winter and there's no residential occupancy allowed, we brought up this topic in our last meeting, and we're considering clarifying in rulemaking that some provisions of section 38-12-212.3 on landlord maintenance of the premises may not apply to seasonal parks in the winter months. So for example, we're looking at whether a seasonal park is required to do snow removal if nobody's living there in the winter. Or we're looking at clarifying whether a seasonal park would have to provide running water in the winter when nobody's living there. So that kind of answers the question.
I'm sorry, real quick, Christy, can you hear me? I'm sorry, I can't figure out how to raise my hand. And you answered a question that I had brought up, and you're using the term may not be required to provide water and may not. And, you know, we own actually an RV park that has some tiny homes on it and got rolled into this because of that. And, you know, our park, one, we can't even provide running water because we have a well system, it freezes, the infrastructure isn't available at our park to even provide it. The pipes aren't underground well enough. You know, then there's a lot of other reasons why. Also, we get 9 feet of snow. It's above, you know, 8,000 foot level, 85, maybe almost 9,000. So, you know, there's so many reasons why, you know, maintaining that and even providing those options, and it's never been open in its history. I guess it's just scary to think that you could potentially require us to remove snow. You could potentially require us to figure out a way to provide, you know, these are vacation owners. The people that are affected in our park are not, you know, low-income housing persons. I'm struggling to understand how this even applies, but, you know.
Yeah, so I was using the word may not because we're still in the discussion process for our rulemaking and nothing is set in rule yet. We are asking for feedback, like the feedback that you just provided, on what type of clarification we should provide in our rules. So I used may because I didn't want to cut off discussion from tenant homeowners who might have different thoughts. But we are considering drafting something that says these certain provisions don't apply in the winter if no tenants are there. If that helps.
Again, and just to clarify, when you say if no tenants are there, so in the history of our park, there have never been any tenants there. Their leases state that they're not going to be there. What else, I guess, is there any way that you can also improve the regulatory requirements to take those things into account, like the history of the park, and that you can't be forced to allow tenants access? There's just things like that I mean, it's part of, we only make money during the summer months. We close down and, we really, other than paying our mortgage and, things like that, the only way we're able to make a business work is because we're able to close down. If we were somehow forced to open and then have people there and pay personnel and pay and try to figure out a way to create infrastructure to have people there, it would literally bankrupt the business. So I'm just, I'd like you to consider those facts when you're drafting these rules.
Yeah, thank you. And that's something we could look at clarifying, if the existing lease or original lease says that they can't be there for certain months, like that's when this exception would apply to this park. That makes sense.
Thank you.
I see Mark R has their hand raised.
Yeah, can you hear me?
Yes.
Yeah, I'd like some maybe clarification or comments on what I see as a gray area in the ability of a tenant to challenge a rule, say an unenforced rule that all of a sudden starts becoming enforced. And it's because there's such of a time gap, from what I understand, between filing a complaint and you guys actually getting to it. I mean, several years from what I hear. So I understand that the emergency rules and the older rules were that if let's say there's a rule that's not been enforced, now it's enforced, or a new rule, a tenant challenges it within 60 days. The rule cannot be enforced by the park owner unless it has something to do with the safety and health and safety of the residents, etc. I'm just wondering if that becomes a loophole for the park owner, and I think it's happened in our park as well, to issue eviction notices anyway, even though the rule's been challenged, under the rubric of, well, it's a health violation or it's a safety violation. There are, in my park in Boulder, there are most of the rules are not enforced. And but once in a while they'll make a threat to enforce them and say they're going to enforce them, and then they don't. So the rules don't get challenged. So the 60 days passes, but they could enforce the rules. So it's sort of a gray area, and it also could be, for example, there's a rule in our park which is never enforced, that you can't have an RV or a camper of any kind. And like many of the rules that aren't enforced, nobody pays attention to it, and it's been they've been allowed since the park began, before the new ownership took over. But let's say they decided to enforce the rule, and under some, maybe somebody could get injured or some excuse, and then if issue eviction notices in defiance of the law. But it seems like there's a gray area there that the park owner could always, and they have apparently, claim that there's some kind of safety issue involved. And then, in the meantime, because it takes us several years for the complaint to go through the system, the tenant is faced with, well, do I risk getting evicted by some judge, or do I comply with it? And, for example, if they said, okay, you have to get rid of your campers or your trampolines, does that amount to 10% of a month's rent, which is in the statute? Probably not, because the park could argue, well, you're making money because you have to sell it now. You're not losing any money, although you're losing the use and enjoyment of something. So it seems like a big gray area, and maybe you'd have some clarification on that.
That is really helpful feedback. I think that there's probably definitely some clarification around the complaint process and rule enforcement that we could work on providing either through this rulemaking or separately through answers to frequently asked questions.
Okay.
Caller at 510. You can go ahead and unmute.
Yes, ma'am, I'm hearing it. What I'm hearing is there's a lot of us that are in similar situations with these laws, and these laws are like just covering major trailer park situations, like city dwellings and stuff like that, and us country folk are kind of getting lumped in with this bunch of corporate size trailer park issues. When we do have these laws come into effect, I mean, something, maybe we should have a committee well, basically what you guys do. I don't know if you guys do it pre-hand before you put a law into effect, or if you're going to look at each situation and see how much of the law affects each certain trailer park every time there is an issue.
Yeah, thank you for that feedback. I think the kind of next step, if you or others on the call want to provide more feedback on the Mobile Home Park Act and some of the changes that we're going over, would be to reach out to your state legislators, your state senator or representative. Right now, the Mobile Home Park Act and the Dispute Resolution Enforcement Program applies to any and all communities that have 5 or more mobile or manufactured homes. So there's an exception for very small properties, so 1 to 4 mobile or manufactured homes on the property. But other than that, the law doesn't make a distinction between size of park or type of ownership of a park.
Yeah, well, there's a big difference between even a 10. I mean, I would, even in 5s, because most mobile home parks are 50 or larger. In my instance, where I'm from, but I'm from a rural area up in the mountains, similar to what the gentleman's getting into with his RV park, and we're just outside of the normal spectrum of your trailer parks, for them to dictate that if you have 5 trailers, you're the same as a place that has 100 trailers. That's just not a realistic exception. I mean, there has to be, and I hope you guys are aware. I think you're aware of that, and I think you're going to take each individual. I'm very optimistic, and I'm hopeful. You guys are going to be for the landlords and the tenants, and are going to take care of the situations that need taken care of, and are going to help either side as those situations occur. But there is a big difference between a rural high mountain trailer court and a city dwelling, even 60, 70 miles away. You know, most of the trailer courts have over 50 trailers in them. I don't see any smaller trailer courts outside of the mountainous areas that are, you know, I don't see any 50 to 100 trailer court housing developments in the mountains. And like you said, that'll be something we'll have to take up with our representative, but you know, they live in a mansion. They don't really care about us, and that's beside the point. So we're just gonna have to be very, we're just gonna have to dot our I's and cross our T's and hope that we fall within your guys' regulations. And I feel that you're going to have to make exceptions, because that's the way laws and stuff work. Laws are and regulations are just doctrine. They're not really, you know, the things that are set in stone. It's not laws are made to be broken, but they are made to be amended, and things are made to be changed if they need to be. And I just wanted to voice that to you smaller guys out there listening in on this. One thing we got to do is stick together and make sure we give these guys the information that they need, so they can adjust these laws and make them in accordance for all of us. Sorry for taking up your guys' time. I do have a lot of questions. And a question into raising rent. When they violate a lease and say, you know, I bought this trailer court a few years ago, and I raised my lot lease for all new tenants is a certain amount. When an old tenant violates a lease, do I have the right to make them fill out a new application, go through the process all again, and even see if they are qualified to rent from me?
So that would likely be a question you'll need to talk over with an outside attorney. We do
Okay.
have some guidance on leases in mobile home parks. Generally speaking, a landlord cannot require a homeowner to sign a new lease. And it may be a violation, or would be a violation of the law, to mislead a homeowner about the requirement to sign a new lease as well. Once they have applied for tenancy and signed a lease in the park, that initial lease, generally speaking, will stay in effect and will automatically go month to month, and the homeowner never has to sign another lease. Now, if the person is removed from the park through a termination of tenancy and then wants to come back in, that would be a situation where you could have someone reapply. But again, any specific situation, I talked to an outside attorney about that. And thank you so much for your good questions. We'll have to go on, but please feel free to reach out to us if you have other questions.
Yeah. You guys are good. You guys are going to get to know me very well. But I appreciate you guys taking the time. On the other hand, on the you know, condemning the park. Now, me as an owner, if I feel that the living conditions aren't good enough and I want to do upgrades, would that be considered condemning myself, or am I allowed? You know, I know that I'm probably, well, it sounds like I'm supposed to do upgrades, but when I got to shut down part of the park to do upgrades, and I got to do it in sections, and I can't just do a big upgrade and fix everybody's problems all at once. I mean, you know, what power
if
do
it's
I
going to
have?
result in the displacement of mobile homes, and you're changing the use of that land by removing mobile homes, that may potentially trigger the change of use requirements.
Okay, well, what if I'm going to put mobile homes back on it?
So I think that's probably a question we'll need to follow up with another time. We can look at whether we can provide some more guidance on that, but
yeah,
it's going to depend on this
and money. If you guys could send me money too, that would be great. Or redoing my trailer park and keeping it a trailer park. But yeah, that's about it. You're doing. I'm really appreciating what you guys are saying. Again, I don't want to displace you guys and make you guys the evil, corporate government entity. And I'm just, again, I'm just grateful that you're doing this kind of process and you have all your stuff accessible online. And I'll let you get back to it. Thank you very much.
And there is a comment in the chat. So there's an organization called Rocky Mountain Home Association, and they assist owners and managers of parks with management and understanding the new laws. And their executive director just wanted me to share their phone number with you, sir, in case you have questions or want to connect with them. So RMHA's phone number is 303-832-2022. I'm going to go back up in the chat comments, cover a few more comments, and then resume going through the slides. So question about the current bill, now state statute, casting a wider net than maybe residents of traditional mobile home parks. So removing continuous occupancy and including tiny homes, which are often operated in tourism-facing businesses. Does anyone know whether the state will implement a way for tourism businesses with out-of-state guests to exempt themselves? That would be feedback for the state legislature. I will note that for the tiny homes, mobile home park or communities with 5 or more tiny homes may or may not fall under our program. It depends whether the tiny homes are built to recreational vehicle standards, RV standards, or whether they're built to the state standards for tiny homes that went into effect, I believe, in 2023, or were built to other like standards more akin to the building and construction standards for manufactured homes. If you have a community that has some tiny homes in it, I would say reach out to us and we can provide you some more information on whether your community falls under our program or not.
That'd be nice. Thank you, Christina. That was my question, and we just think we're being targeted. I don't think the legislation was intended to to cover simply tourism related businesses like ours, although it has. So anyway, I know that's a legislative issue primarily, and we just wanted to find out more. So we appreciate your time.
Thank you. A comment that relates to a question that came up in our last meeting. Is it a request for some clarification on whether it would be a violation of the act that could be found through the complaint program just for a written rule and regulation of a park to be in violation or appear to be in violation of the statute versus when the landlord tries to enforce the rule or regulation. The section of the Mobile Home Park Act on Park Rules 38-12-214 says a landlord may enforce a rule if it's for certain purposes, etc. Under that first subparagraph 1 about rule enforcement, it is looking at whether the landlord's trying to enforce the rule or not. Other sections of 214, it may be less clear, so we can look at whether that's something we can clarify to your question, Carol. A comment about exceptions for seasonal and vacation type housing for small communities. Again, that would be feedback for the state legislature. Comment about Challenges around rule enforcement due to lack of staffing, especially rule enforcement surrounding number of parked cars. Now that the park does have a code enforcer, tenants are not happy with the enforcement. Are we liable for complaints on the new enforcement rules? A homeowner can submit a complaint to the oversight program regarding a park rule at any time, so not just during the 60 days after it's noticed. If we did receive a complaint about rule enforcement, we would investigate that, reach out to the landlord and get their feedback on the purpose of the rule and their response to any other allegations in the complaint. So that could fall under the complaint program. I will say that towing issues, we will generally refer people to the Public Utilities Commission because they have a specific section that works on towing and towing complaints. A comment that directed at the gentleman who previously had feedback on small parks. This is a resident of a small park in one of the largest of their county. Part of bringing the law or the threshold down to 5 units is due to bad actors of these parks and the act not originally covering those residents. A park larger than mine by 3 units went almost 3 years without appropriate water resources, so 28 units in the park. Let me go ahead and go through the slides. There's a comment about posting of rules. We will see if we're able to get to it in this meeting, or we'll have to follow up on that topic. So there are several provisions in the new law that go into effect on June 30th around language access. And so that's what these next couple of slides are about. So in 2022, changes to the Mobile Home Park Act were made, stating that a landlord is required to host a community meeting when it's requested by a resident within a certain time frame, and that but they're only required to do that twice a year. So there are some updates to that section of the statute, that landlords have to post notice of the meeting in English and Spanish and any other language reasonably known to be spoken by more than one resident of the park. And then upon the reasonable request of a resident, at least 7 days before the meeting, the landlord has to provide and pay for an interpreter at the meeting and translation of any documents or materials for the meeting. And then the division is encouraged to publish a list of available resources for interpretation services on our website. We will be doing that in the next week or two. I'm going to go through these kind of quickly in the interest of time. Please feel free to put feedback in the chat. We are going to save the chat and we'll read the chat after the meeting in the event we don't get to discuss anything. And then there'll also be information on providing written comments at the end of these slides. So starting June 30th, landlords are required to establish a unique mailing address and mailbox for each lot at the park and include the mailing address in the rental agreement moving forward. These mailboxes can be located in common areas or on individual lots. And this requirement doesn't apply if U.S. mail service is not available. Landlords must provide any notice, disclosure, or other communication that a landlord is required to provide to a resident in English and Spanish This will include rental agreements, and it will include park rules and regulations. This is effective June 30th. At any time, a resident can ask the landlord to provide a notice, disclosure, or other communication in one additional language spoken by the resident. After that point, landlords have to provide required communications to the resident in their requested language. So required communications would be things like water shutoff notices, notices of community meetings. So a question, where can I find a current version of the Mobile Home Park Act? There is not a fully current updated version available yet through the Colorado Revised Statutes posted on the General Assembly website. We are told that, or think updates might be available in July, and we're looking at what we can provide ahead of that, but there are no official updates to the statute books that I'm aware of that are available yet. We can provide a link to the bill, which has the new language. And there, Michelle just provided that. Good question, comment, are they required to do leases in other languages? My initial thought is yes. Because a lease would be a notice, disclosure, or other communication. But we can look into clarifying that further. In addition to a written notice that might be provided, a resident can ask the landlord to provide that written communication verbally one time. The landlord must read the communication aloud to the resident or provide an audio or video recording within 72 hours. Landlords must ensure that notices, disclosures, or other communications are written in clear and plain language and include all information reasonably necessary for residents to understand their rights and responsibilities. Translations must accurately convey the meaning of the original communication. And the communications must be clear and unambiguous to ensure it's easily understood by all residents. And these are requirements in state statute that go into effect on June 30th. Residents can respond in English or Spanish to any notice. A resident who's asked the landlord to provide communications in another language may respond in that language. And if requested by a resident, the landlord must provide an interpreter or interpretation in one language in addition to English and Spanish, and this could include American Sign Language. Looking for feedback on how far ahead of time, or one thing we're looking at clarifying is how far ahead of time a resident should be required to make an interpretation request. They don't believe that's currently in statute. So landlords must provide rental agreements in both English and Spanish upon request. A written copy of park rules and regulations in English and Spanish. I have a question here about whether clarification is needed on whether landlords are required to translate existing rental agreements into Spanish or another language upon request. It's an additional provision added to the existing prohibition on retaliation that says a management's action, so something like increasing rent or decreasing services in a selective manner or excessive manner, that action is presumed to be retaliatory if in the last 120 days, the resident asks the landlord to provide communications in a language other than English. Here is the update on park rule changes. So at least 60 days before a park rule change, the management must provide written notice in English and Spanish, post the amended rules in a common area, and post the amended rules on each homeowner's lot. Jennifer, did you have specific questions or items you need clarified from this section?
Yeah, I just wanted to make sure that if we aren't changing rules currently, there's no need to post that until we do make changes in our rules, and then it has to be posted like is written here in both English and Spanish, correct? And on the homeowner's lot.
Yes, I believe these specific requirements apply just to a change in the rules. If you have any new tenants, you will need to provide them copies of rules and regulations in English and Spanish. And then we're looking at clarifying whether the copies of rules might need to be provided in Spanish to existing tenants.
So you're saying the current rules should be given to them in Spanish now, or not, only if we make a change in the rules to current tenants?
Only if you make a change is my understanding on the section regarding posting. We need to look, the division's gonna be looking at clarifying this section, whether rules and regulations might need to be provided to current tenants in Spanish, either upon request or across the board. But we have not clarified that yet.
Okay, that helps. That helps a lot. Thank you.
Comment around whether parks should be allowed to change rules. In the current Mobile Home Park Act, the landlord is allowed to amend rules with 60 days written notice. However, there are a lot of restrictions around now under current statute around the types of changes landlords can make for existing homeowners when it comes to rules that affect the home itself. So there are a lot of restrictions on landlords being able to change rules that apply to the home, the appearance of the home, what you can do in the home if you're an existing tenant. There are some additions to the requirements for landlords to maintain tenancy records. These record requirements went into effect a couple years ago. Effective June 30th, landlords must also retain records, including requests from residents that communications be provided in a language other than English, a payment ledger, and then communications provided to residents who've requested communications in a language other than English. And then landlords must provide a copy of the payment ledger if it's requested by a resident within 10 calendar days. I mentioned earlier that our current rules say landlords need to provide copies of other tenancy records that are requested within 10 business days. So the question of whether we should update that to 10 calendar days, so it's the same time period for all record requests, or keep it separated because business days provides a little bit more time. No, went through those last slides quickly. My apologies, Valentina, for talking fast. Great, see great comments and questions in the chat. Comment around whether tenants need to sign a lease and rules and regulation in English and Spanish. That's not clear in the statute, so that may be something that we can look at clarifying. Really appreciate everyone's participation today in the conversation. We would love to get your written feedback as well. So it can be sent to our program email address, mhpop@state.co.us. And please include rulemaking or MPOP rulemaking in the subject line of the email. You can also mail us your comments if you don't have access to email. That will be to the Division of Housing. Put attention MPOP rulemaking. Our address is 1313 Sherman Street, number 320, Denver, Colorado, 80203. A question about whether there's anything in the new statute around water use. There are some new provisions that we touched on in the last meeting and we'll touch on in next week's meeting related to how much water the landlord has to provide if there's a service disruption. But not specific to water billing, which sounds like might be your question. Comment from a co-op owned park that there is an issue with deteriorating mobile homes with siding and trim rotting. There's a concern about the deterioration from the aspect of a resident losing equity. At some point, it does become a health and safety issue. It would be appreciated if you could add this to rulemaking for this topic. So one provision of the bill that we mentioned at the last meeting is a provision that allows the division to make rules that say a certain type of rule or regulation is presumed unreasonable or is presumed to be reasonable and enforceable. We could look at that, whether that like allowance might apply to this situation. I imagine this may be a topic of interest, not just for the co-ops, but for other mobile home parks. So interested in your feedback, Dan, if you have any written feedback or if you wanted to briefly make any comments to clarify your comment. Well, thank you to everyone for joining the meeting. I really appreciate the respectful feedback and conversation. Again, please feel free to contact us after the meeting, submit written thoughts or comments that you have. Some issues, again, we're going to try to address through this rulemaking. Some we might have further discussions on and address in a future rulemaking. But really appreciate your time, and I'm just gonna stay on a minute so we can save a copy of the chat and go ahead and end the recordings.